New York Teen Sexting Resources for Parents and Victims by attorney Andrew M. Stengel. The widespread use of smartphones, social media apps like Instagram, Snapchat, and TikTok, and dating apps such as Tinder, Bumble, and Grindr has resulted in a sharp rise in teen sexting. A parent's worst nightmare is learning that an intimate image of their teenage child is being texted among other kids, or is publicly posted on the web. Parents and victims are not powerless in the fight to stop the spread of intimate images, with the goal of the destruction of the images. An experienced teen sexting lawyer can take important legal steps to protect victims of teen sexting or revenge porn, which are crimes in New York. In addition, New York's revenge porn law allows victims to sue for damages and the removal of intimate images. The New York Teen Sexting Legal Toolkit. A teen sexting and revenge porn lawyer's legal toolkit includes legal agreements, consent removal requests, family court petitions, a lawsuit under New York State or New York City laws, intervention by the local school district, and police reports. There isn't a one-size-fits-all response for a victim of teen sexting or revenge porn. The factors to consider when formulating a response include the nature of the intimate images, the means of disseminating or publishing the intimate images, and the number of people or entities who were sent or possess the intimate images. Each case requires a unique and strategic approach. New York teen sexting crimes. Victims of teen sexting and revenge porn have power because of New York's criminal and civil laws. New York teen sexting crimes include unlawful dissemination of publication of an intimate image, New York's revenge porn law, which is a misdemeanor and applies no matter the age of the person depicted in the intimate image, promoting a sexual performance of a child, and disseminating indecent material to minors, which are felonies and apply if sexual content is sent to or received from a person who is under 17. Possessing a sexual performance of a child, which is a felony, and applies to possession of sexual content of a person who is under 16. Copyright agreements. The author and the initial copyright owner of a photograph or a video is the person who shoots or takes the photograph or video. If a teen takes a photograph or video that contains intimate images, then he or she already holds the copyright. But what if another person takes a photograph or video that contains an intimate image or sexual content? A copyright assignment transfers the ownership of a photograph or video typically to a parent of the teenager depicted in the sexual content or to an adult victim of revenge porn. The parent or victim can then enforce the copyright against any website or application that publishes the intimate images. Non-disclosure agreements. A non-disclosure agreement can bind a person never to disclose the existence of intimate images and require the destruction of all sexual content, whether photographs or videos. The agreement can state penalties for the continued possession of intimate images and consequences for the future possession and/or transfer of intimate images if not destroyed or later discovered. Non-disclosure agreements are legally binding contracts, and violations of an executed agreement could result in civil penalties. In addition, non-disclosure agreements can indemnify the victims against future losses or costs for breaching the agreement. Content removal requests. There are two types of content removal requests: non-consensual nudity policy violations, takedown notices under the DMCA or Digital Millennium Copyright Act. Most social media applications, such as Instagram and TikTok, do not allow content that includes nudity or sexual content. But other social media sites like Twitter or porn websites that allow sexual content have non-consensual porn or nudity policies, including a ban on posting or sharing intimate images that were produced or distributed without a person's consent. Under the safe harbor provision of the DMCA, websites, applications, and hosting companies are protected from liability based on allegations of copyright infringement if they take down content when presented with a notice of copyright infringement, called a takedown notice. Family court orders of protection. A teen sexting victim may obtain an order of protection to protect a person from further communication or contact with a perpetrator and/or dissemination of intimate content. There are two requirements to file a petition for an order of protection: a type of relationship between the person seeking the order of protection and the other person, and an allegation of a qualifying crime. The person seeking the order of protection and the other party must be in or have been in an intimate relationship, be related by blood or marriage, are or were legally married, or have a child in common. The qualifying crimes include unlawful dissemination or publication of an intimate image, harassment, aggravated harassment, sex crimes, and many domestic violence-related crimes. Teen sexting and revenge porn lawsuits. New York's revenge porn law created a right to sue for victims of teen sexting for the unlawful dissemination or publication of an intimate image. Victims of teen sexting and adult victims can sue both the person who disseminated or published the intimate image for damages, as well as a website, application, or service provider for permanent removal of intimate content. A person depicted in a still or video depicting an unclothed or exposed intimate part of a person or sexual conduct can sue when the intimate image is disseminated or published without their consent, or a threat to do so when a person expected the image to remain private, even if the image was consensually obtained. There is a 3-year statute of limitation for a lawsuit, or a 1-year limitation from the date of discovery, if a person later discovers the publication or dissemination. New York's Dignity for All Students. New York passed the Dignity for All Students Act in 2012. The Dignity for All Students Act created definitions for bullying, which now includes cyberbullying. The law requires schools to address harassment, bullying, and cyberbullying in their codes of conduct. Harassment is defined as the creation of a hostile environment by conduct or verbal threats, intimidation, or abuse that has or would have the effect of unreasonably and substantially interfering with a student's educational performance, opportunities or benefits, or mental, emotional, or physical well-being. Teen sexting may be a violation of school policy, even if it occurs off school grounds. Former New York Assistant District Attorney Andrew M. Stengel is a zealous advocate for victims of teen sexting and revenge porn in New York and New York City. Andrew M. Stengel is an experienced trial attorney, a diligent investigator, and an aggressive advocate. For more information, visit the website of Andrew M. Stengel, www.stengellaw.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.